Thank you very much. I appreciate the time this evening to provide testimony in favor of this bill. I am an attorney. I'm licensed in Rhode Island and Massachusetts. I primarily, for the last 25 years, I've primarily handled surrogacy matters, either drafted surrogacy agreements or represented carriers who are signing a surrogacy agreement. I actually attempted to have my own children with the assistance of a gestational carrier 27 years ago. My ex-spouse and I wanted our own genetic child, and we had a friend step forward who would serve as our carrier for us. Of course, the technology back then is not what it is today. We had 2 embryo transfers that failed, and we ended up adopting twins who are now 26 years old. But in any event, today, if I was younger and the technology is what it is, I would certainly, most likely, go the surrogacy route and probably be successful at it. But in any event, I'm here to testify that this bill is a very positive bill, and it does support protections for all parties. In any surrogacy contract that I've been involved in, either drafting it or reviewing it with a gestational carrier, there are certain criteria that are covered in the contract itself, and this bill covers every single one of those elements. The carrier, all parties have to be at least 21 years old. The carrier must have had her own children. She has her own children before she can serve as a carrier. The parties must be medically and psychologically evaluated and cleared to be suitable. All parties must be represented by their own counsel. One of the parties, according to this bill, one of the parties must be a resident of the state of Rhode Island, or at least some of the evaluations have to be conducted in this state. So we don't have folks from other states coming into Rhode Island because there's such a favorable law here. The parents, according to the bill, the parents will be named they will be the exclusive parents of the child, and primarily and exclusively responsible for the support of the child. The contract must allow the carrier to make decisions relative to the pregnancy itself. If the pregnancy threatens her well-being, she has full discretion to either terminate or reduce the pregnancy. The bill also provides that any parentage order can be entered before birth, the day of birth, or after birth, and that is important because there have been cases that I've been involved with where either the parties came to me late, and therefore I'm preparing pleadings to file in the court that may not make it before birth, or the child is simply born premature. So to be able to go into court after birth and obtain a post-birth order is critical. The gestational surrogacy portion of this bill is comprehensive and does a fantastic job of safeguarding the rights of the parties. Again, all of the required elements that I see in any contract across the country that's being used in any state across the country, those requirements, the requirements I see, the elements I see in those contracts are covered by this bill. The gestational carrier contracts I typically draft, again, the parties are represented, they're evaluated. We make sure that there is sufficient insurance to cover the prenatal care and the delivery, because in the end, and according to the contract, the terms of the contract, the parents are responsible for the prenatal care and responsible for any delivery costs that are not covered by insurance. So we always make sure there's adequate insurance coverage. Our neighboring states, Connecticut, Maine, and New Hampshire, have all recently passed legislation that closely mirrors this legislation. In all 3 of those states, courts may enter pre-birth or post-birth orders. The intended parents are not required to be married. Same-sex couples benefit under those statutes. Single individuals benefit from those statutes who wish to parent on their own. Massachusetts and Vermont currently have bills pending that are doing very well. At present, there are 44 states in this country that acknowledge or allow gestational carrier arrangements either through legislation or case law. In Rhode Island, at this time, what I do is I file an equity petition in the Superior Court to declare parentage. And the presiding justice, Gibney, feels that the Superior Court has adequate equity jurisdiction to entertain these petitions. But of course, what happens when a new presiding justice gets appointed? Without legislation, the parties, we're all insecure with respect to what's going to happen and what we can expect. Briefly, with respect to the generic surrogacy portion of the bill, this involves a woman who's serving as a surrogate, but it is her egg, it's her biological egg that she carries for an intended parent or intended parents. This bill protects the surrogates, protects their interests in that it gives the surrogate 3 days after birth to withdraw her consent to the contract that she signed earlier if she wishes to retain her interests. And that's important, of course, because she is the biological parent of the child. This bill also is positive and protects the parties in that, unlike just the gestational carrier portion of the bill, parties entering into a genetic surrogacy arrangement, they need to go to court first. They need to go to family court first, present the contract, and have the court approve the contract. So all parties are represented. They go to court. They get it approved by the court, and then they proceed with the procedure. So, in essence, this bill, in terms of the surrogacy requirements, is very comprehensive. It's very thorough. I believe that it protects all the interests of the parties involved, and I'm very much in favor of it. I wish this statute was around 27 years ago. To protect my interests and the interests of my carrier. Thank you.